Prosecutors are people too, and in some situations, you can persuade them on a human level of what the right outcome is. And sometimes we go to trial, even when the client gets convicted. By the time we go to sentencing, after the prosecutor has seen our sentencing submission, our mitigation report, all these wonderful things, sometimes the prosecutors tell me, you got through to us, or you had us going with what the right outcome is. And sometimes you are able to get some sort of break on what the sentence is if you're able to persuade the prosecutor on a human level. And we had a case where we did, I think, a very good job putting together the explanation of why the case happened. It was after the client pleaded guilty. It was an open plea. The prosecutors actually agreed to a number that I don't think they would have gotten to. They've given a much lower recommendation than where I think they were after seeing just the submission and the letters of support and everything that we've put together. So I definitely think it's worth a shot if you either have a federal case or an open plea to go out, get a mitigation specialist, do letters of support, try to explain why the case happened or just what path you were on as a person, and how there was no turning back for you, and that's how you ended up in the criminal situation if you just fell into a criminal case or something mega serious. Definitely worthwhile. Not to say it works every time, but it's worth a shot. And ultimately, what do you have to lose at that point if you're not pursuing an appeal? Just to explain in realistic human terms what you've been through, what your background has been, and how you ended up in the middle of a massive federal case. And I think prosecutors get it. Not every time, but sometimes if your lawyer does a good job on a submission, they may come off what their recommendation was. Not necessarily, well below guidelines, but maybe they'll be asking for the bottom range of the guidelines instead of the top range.